As motion lordship.
Simpler prayer, my lord.
Oblige, your
Simply
Tomorrow.
motion matter, fresh motion. Yes.
Yeah, please, Your Lordship, I beg to mention item number 8. This matter may be taken
Item
up. Number 8.
8.
That's okay. This matter may be taken up after vacation.
You are mentioning on whose behalf?
SK Talukdar.
Item 8 at the request of counsel for the petitioner stands deferred for 2 weeks.
Obliged, Lordship.
Mr. R.M. Das appears for the.
No, Lordship.
You are not appearing here.
No, I'm appearing.
State acknowledged.
M.S.M. Bormon appears for the state of Assam.
Lordship, with due consent, Lordship, if your Lordship permits, item number 40 and 41 may kindly taken up as first item, Lordship.
Oh, 40 and 41.
Lordship, yesterday as your Lordship has
Where is the other side?
Lordship.
40 and 41.
Lordship.
What were these matters?
Lordship, regarding the cancellation of the permit, Lordship.
Oh, okay. All right.
Deeply.
40, 41 first item. Yes.
May I please?
Lordship, I beg to mention item number 23. The engaged counsel, Mr. R. Singha, is out of session and could not appear.
Item
today.
23 at the request of counsel for petitioner stands deferred. We listed after 3 weeks.
My lord, with the consent of the other side, my senior, my lord, I am mentioning item number 25. My lord, here we are supposed to bring one record, my lord. So, my lord, we could trace that record, my lord. The record we have found, my lord. So, my lord, this matter actually pertains to now social justice and empowerment, my lord. So, my lord.
So you want an upgradation today?
No, my lord.
You want an adjournment?
Adjournment, my lord.
Item 25 at the request of Mr. R. Thought. Matter stands deferred to be listed after 2 weeks.
After vacation, that is
after 3 weeks.
Three
Mr.
weeks,
M.
my lord.
Coronia appears for the writ petitioner.
First week of January, maybe second.
We listed on.
Before Mark Bihu.
We can have it on 10.
Well,
10. Oh, this is a hearing matter.
hearing matter, my lord.
All right, then it has to be on 21st or 23rd. Sorry.
23rd.
23rd January. 23rd January.
My lord.
My lord, we'll just record one thing, my lord, that the record has been found, my lord. This record.
We are not recording anything. You appear and produce the record, whatever is there.
My lord, the record was with the government, my lord. They have traced out, my lord, my learned has to appear with the record.
Now he
Either
has
my
to appear
presence
with the
can
record.
appear.
No, you have traced out, so you hand it over to him.
No, my lord, the thing is that otherwise I have to rewrite it to Dispur. Again, it will come back. Because, my lord, this record initially it was brought by this.
The records necessary for the case be retained by the council. By the which department?
Social justice and empowerment. RM Das.
Social justice and empowerment by Mr. RM Das, represented by Mr. R. Yes.
I love
May I please, Your Lord? Lastly, I beg to mention item number 36, Your Lord. Matter become infructuous.
36.
Yes, Lord.
At the request of the submission of the learned counsel for the petitioner is submitted that the matter has become infructuous and therefore he'd like to. Petitioner does not wish to press for the same. Writ petition stands dismissed as infructuous.
Sure.
Mr. Lordship, I'm seeking for an urgent I, which your court has allowed, but the matter has been registered, but it didn't come up today. Matter may be allowed to come up tomorrow, Lordship.
What matter?
I.
IA for what?
For an order passed by the Honorable Court. Lordship.
Correction.
Yes, sir. Correct.
All right, tomorrow.
Yes. Please, Your Lordship. Lordship, I beg to mention item number 38 of the supplementary list. Lordship, I would like to withdraw this matter, Lordship.
The submission of the counsel for petitioner that the petition has become infructuous, matter stands dismissed as not pressed. Promoters, if any, stand vacated. According to 36 for to promoter, if any, stand vacated. Yes.
So I'm for respondent number 2 and 3.
Here appears for the respondent, income tax.
Deeply applied.
May I please, Your Lord? Listing of the case after vacation, Your Lord.
After vacation, why you mentioning now? Mention after vacation.
But on 3rd January, Your Lord.
Why? What is the need for having it listed on third? For what? The admission orders, hearing,
Admission.
admission matter. Will it come in the week after that or on 8th of January?
On 8th.
Your lordship has yesterday queried why that principal secretary, your lord,
Some it has been cancelled.
yes, lordship, the mining part, because of the issuance by the principal secretary. Your lordship had queried why that has been done. That has been done because of this letter, lordship, which the DFO had issued to the principal secretary, lordship. Lordship may kindly peruse second para. The DSR for Dimahasov was approved on so and so date.
What is DSR? District Survey.
District survey report.
Yes, Mr. Solomon.
Lordship,
I am perusing
No,
on copy.
yeah. I've seen it just now, Your Lordship. Now, this letter is 12/11/2024.
Yes.
By this letter, the DFO requested the Principal Secretary to consider cancellation of any mining permit.
Mm.
And on the basis of this letter, on 30/11/2024, the
Mining to cancel.
Yes, 1311.
13/11 informed that the North Panchayat approved your suggestion for cancellation. Now, from by first letter 12/11, a request was made for consideration of mining, and that was approved. And as per my understanding, both Your Lordship, I think thereafter a cancellation order has to be issued, and that must be communicated to me. It's mandatory, Your Lordship, because I was the existing. Presently I am the existing mining lessee, Your
You
Lordship.
communicate the cancellation order.
Yes, lordship, we will. Because
How many days would you require?
lordship, this is for whole, means for entire uniform.
But you have to
Yes,
issue
yes, yes.
individual communication letter.
I think, yes, lordship.
Do it by Friday.
Yes, lordship, we will.
Huh?
We will.
By tomorrow.
Yes, lordship.
Even if I get the cancellation order by tomorrow, Your Lordship, by the time I challenge the cancellation, my mining days will anyway be over. So may I pray that this matter may be pending. I am not praying for any interim as on date. So let the matter remain pending, Your Lordship. Notice, let everything come on record, Your Lordship.
Then you bring it on record.
Because I have a-
affidavit including the communication given to the.
Yes, because in this petition, I have a prayer for extension of the lease also because of the loss that I have been suffering since the month of
But
July.
in view of these letters, it can be considered now.
Lordship, because of these events, Your
I
Lordship.
heard Mr. P.K. Sharma, counsel, Mr. R.M. Das, hearing from NC Hill, Autonomous Council. Mr. Das has produced two communications, one dated 12/11/2024, by which the Divisional Forest Officer, Dimahasao Forest Division, West, Aflong, had requested the Principal Secretary within bracket N, NCHAC Aflong, to consider cancellation of any mining permits within bracket for minor minerals issued prior to the district survey report within bracket DSR approval date. Stop. On the basis of the said communication, the Principal Secretary N in charge, NC Hills Autonomous Council, issued a communication dated 13/11/2024 cancelling all mining permits for minor minerals issued from that office with immediate effect. So, Mr. Das, on the basis of his communication, submits that the mining lease of the writ petitioner was issued prior to the approval of the district survey report DSR, which came to be approved on 5/10/2024 for the district of Dimahasao. So therefore, in pursuance to the suggestion put forward by the Divisional Forest Officer, Limahasa Forest Division West, Haplong, the Principal Secretary N, within bracket N, IC, in charge, NC Hill Autonomous Council, Haplong, by the communication dated 13/11/2024, cancel all mining permits issued. Stop. This accordingly, the mining permit of all persons similarly situated like the petitioner, including that of the petitioner, stood cancelled with effect from 13/11/2024. Para. Mr. Sharma, learned counsel appearing for the writ petitioner, the other end, submits that these communications were never served on him. He has not received any specific order for cancellation of the mining permit. He therefore submits that these documents ought to be placed on record by the respondent department. Mr. R.M. Das therefore submits that he would like to place these documents on record by way of an affidavit, and he prays for 2 weeks further time. Let the matter be listed immediately after reopening on a date to be fixed in the registry, by which time the writ petitioner respondent will file necessary affidavit in the matter.
One technical problem right now, I'm just submitting your document. I have a prayer. My prayer number 2 is to issue a direction to extend the validity of petitioner's permit for extraction so as to enable the petitioner to extract the remaining balance quantity of this. So this prayer only if this prayer will remain, the issue regarding extension will remain open if that much is given as an
We are
input.
not saying anything.
But this prayer is valid as on date because my license is valid.
License all been cancelled.
I mean to say the
See,
date.
if you want, we can close it by saying that your prayer may be considered by the, if permissible, may be considered by the authority. They will pass whatever orders are there. Or as you say that you have not received copies, therefore we have.
Lordship, that I understand. My only concern is technically this prayer is valid today because my
If the cancellation is illegal, then this prayer would remain valid.
even after expiry of 30th.
What about the second matter?
Same lot.
Same. 40/41.
Got
Civil road.
Highly obliged.
You are appearing for both,
Both.
and both have mining permits for Dimahasam.
Lordship?
Both matters, the mining.
Yes,
Mining.
similar. Same area, everything similar.
All right.
Obliged.
Deeply obliged.
Where is the order?
Lordship operative part at page 13, your Lordship, paragraph 11. 11 and 12, paragraph number.
Part being
Yes, I am.
alleging willful disobedience. The directions contained in the order dated 14/8/2024 passed in WPC 5140/2022. The contemplation has been filed. Issue notice. Steps on the respondent by usual course, registered post within respondents within 3 weeks from today. Matter be
So,
listed after returnable date.
May I please, Your Lordship?
Where is the order?
Annex 30, page number 23.
Same order. Order of the court dated 27/9/2024
Service may be
passed
required.
in WPC 5036 of 2024. Notice issued.
Lordship,
4 weeks. Steps on respondents by 3 weeks. Within 3 weeks by usual course, registered post. Yes.
May I please? My lord, the order passed by this honorable court, Lordship will find at page 212.
Yes.
And operative part, Lordship will find at page 224. Page 224.
All right.
my lord,
Alleging
in terms,
willful violation, deliberate violation of the directions contained in the order dated 6/8/2024, passed in the PPT number 5324 of 2023. This court petition has been filed. Issue notice, returnable 4 weeks. Steps on the respondent by usual force, registered force within, on the respondent within 3 weeks from today. Yes.
developed.
This is your lordship. My lord, here, my lord, petitioner had been given allotment of a ticket booking counter for small commercial vehicles by the ASTC, my lord, and by the allotment order dated 11/3/2015, my lord. So on the basis of that allotment order, he was running the booking counter, and only on 30/9/2015, my lord, suddenly, my lord, he's
39?
30/9/2015, my lord.
Uh,
By the respondent authorities have tried to dismantle his, my lord, booking counter, my lord, on the basis that his allotment was cancelled. The petitioner had no knowledge because the cancellation order was of the same date, my lord. Your lordship may kindly say I've annexed the orders at page
there is
21.
already,
Yes, earlier I have approved this honorable court.
where is that order?
And order is at relevant portion, page 30, my lord.
30. So there was the direction to consider your case.
Yes, my lord. The hearing was taken, my lord. After hearing, my lord, they have rejected my prayer, saying that my lord, that the land being handed over to the railway authority under the direction of the government of Assam. But my lord, there are still space, my lord, near the parking lot of the of Colton Bazaar, my lord, ASTC, my lord. So
No,
they
but
can
if it is handed
accommodate
over,
the
if it
petitioner.
is handed, if it is handed over to the railways, it
Yes,
has to
ma'am.
be the railways. Have you?
Not the, my lord, total, my lord, area has not been handed over, my lord. My lord, where the parking lot is there, my lord, there's still space available,
Where is
my
the
lord. They
standing
can
council?
accommodate
Standing
the-
council for transport? Transport? Is it ASTC? Who's for ASTC?
because the petitioners are unemployed youth since 2015, my lord. They earlier they had got the
No,
allotment.
see,
And
it can't be a direction only in favor of the petitioner. There may be so many
they may
unemployed youth.
reconsider, my lord,
No. How can there be a reconsideration?
considering the space, my lord,
So
available.
you find out your colleague and then come back.
Yes, ma'am.
You inform your standing council for ASTC.
There, my lord.
Scroll.
There.
Mr. J. Roy.
Yes, he was there.
Find
Now,
out
my
who's
lord,
there.
whether he was, not, my lord.
You find out, we'll take it up after a while. Good morning.
My lord, in this case, my lord, the petitioner, my lord, filed application before the Central Information Commission, my lord. That is the appellate authority, seeking some information, my lord. First, my lord, public information officer. Then it was not furnished, my lord. Thereafter, appellate authority. Appellate authority, my lord, by the annexure 5, your
Who
lordship
appears
will-
for the respondent?
my lord, the respondents here, my lord. UGSC, my lord. Union of India, then my lord, Public Information Officer.
Accountant General. There is a standing council for Accountant General, and you are appearing for Accountant General?
I'm CGC, my lord.
CGC, and who's for Accountant General?
My lord, it is, my lord,
Mr. Dhor.
Mr. Dhor.
Dhor is there.
Accountant General of.
The names are not reflected.
Lordship may issue notice, my lord.
No, we
Returnable-
don't want to issue notice like this.
My lord.
Why should we issue notice? Unless you are able to satisfy us.
My lord,
You satisfy us that this is a case which requires issuance of notice.
my lord.
Have you received copies? Have you served copies on the respondents?
Yes, my lord, I have. My lord, the names has already been appeared as CGSC, my lord.
Scroll.
Mr. C.K.S. Borua
Uh,
in the cause
Accountant
list.
General and CGC. CGC is here, but Accountant General. All right, wait for some time. Let us see. Please inform Mr. Dotto. Please inform, if possible, any counsel for Accountant General. You're for Accountant General. All right. Please get instructions why the information sought for by the petitioner has not been supplied under RTI from the PIO, Accountant General. You served copies on him.
My lord,
Mr. B.K. Sen appears for the petitioner, Mr. A.K. Dotto for the Union of it. Huh? Union as well as accountant.
Union, he may be appeared.
Mr. A.K. Dotto for Union and Mr. S.K. Mehdi appears for the Public Information Officer of the Principal Accountant General, A&E, and the Appellate Authority Public Information Officer, Office of the Comptroller and Auditor General. So, the petitioner is aggrieved by non-furnishing of the information that he has applied for under the provisions of the RTI Act.
For 2 and 3, I will apply.
That's right. We have recorded it. Let the standing councils appearing for the respondents obtain their instructions in the matter, and matter be listed after 3 weeks on a date to be fixed by the registry. Let extra copies be served on the respective councils to enable them to obtain the required list in the month of January.
Well,
In the month of January,
last 29th of January, my lord.
29th of January, all right. 29th.
I live.
obliged, my lord.
It's regarding the rejection of the applications by the learned special tribunal. Your Lordship, Kamrup Metro, Guwahati, Your Lordship. The rejection order is annexure 26-140, whereby the repetitioner's application for land grabbing, Your Lordship, has been rejected only on the basis of the report furnished by the circle officer, stating that the
You're challenging an order of the court, of the order of the tribunal.
tribunal.
There's no appellate forum further.
That is why this division bench and also this honorable court I have annexed the annexure 27, page 114, has been clarified as 10, Your Lordship. Since there is no tribunal has been appellate authority has been constituted, so read is amenable.
114.
Page 141, annexure 27. This honorable court has, on a similar circumstances, has been disposed of the petitions, Your Lordship, and revert back the matter to the learned court special tribunal for first consideration.
That we'll consider, but where is that order you were referring to? Saying that
Page 140,
140.
annexure 26.
I heard Mr. H. Borua, counsel for the petitioner. M.S.S. Kwon, appearing for respondent number 1 and 2. 1 and 2. 3. By name.
By name. I don't know.
1 and 2.
1 and 2.
Since the respondents 1 and 2 are represented by the government advocate, notices are waived. Extra copies be furnished within 2 weeks from today. Steps on respondent 3 4, 5, 6, 7. By usual course, registered post 80. Trustee is also permitted. Steps to be undertaken within 2 weeks from today. Petitioner is before the court, putting to challenge the order dated 14/8/2024, passed in session within bracket LG, case number LG bracket close, case number 14 of 2022, whereby the petition filed by the petitioner alleging, making allegations against the respondents for land grabbing under the provisions of, what is that act? What is that act?
Lordship,
What is the name of the act?
Assam Prevention of Land Grabbing Act 2010.
Assam, making allegations against the private
Assam
respondent
Land Grabbing Prohibition Act 2010.
under the Land Grabbing Prohibition Act 2010. Stop. Issue notice, return among 4 weeks. Matter be listed after completion of, after the returnable date.
Deeply.
Unappealed. Matter stands passed over.
In this case, they challenge the virus of section 168 capital A. The writ petition lies before the division bench.
Who is appearing for the petitioner?
The Petala was cleared. 9. 9 to 9. Mid World Cup. As per chapter 5, rule 2E, the writ petition lies before the division bench.
Lord, may I submit, my lord?
Yes.
My lord, I have come before your lordship against this GST order, my lord, on 2 counts, my lord. On 1 count, my lord, this bench, my lord, ordinate bench of this court, my lord, has already single bench, my lord. Single judge, my lord, Justice Honorable Justice Devajit Barua, my lord, already has passed an order, my lord. And in that case, my lord, I think Mr. Kayal was also appearing in that matter, and it was a single bench.
No, why do you say it's before the division?
Lordship, page 22, kindly, of the writ petition.
22, yes.
Grade 2.
What is the TOLA Act?
That is
The taxation law amendment, my lord, to which 168 has been inserted, my lord.
So they have challenged this one. So let's say under chapter 5A, E.
Well, the act is in page number 91 of the petition, my lord.
So as per High Court rules, Lordship, the appeal lies before the.
What are you challenging in para 2? What is the essence of your para 2?
My lord, my lord. My
Where
lord,
at para 2? Page number 22.
22, my lord. My lord, to declare, my lord, 168 to be ultra vires.
So it has to be before a division.
My lord, here, for this judgment of this honorable.
No. If you are challenging the virus of a section, it has to be before a division.
In this case also the virus was challenged, my lord.
Whatever it may be.
I'm covered by a judgment, my lord.
You are covered, you pointed out before the appropriate bench. The High Court rules are very clear. If you are challenging the virus, then it has to be before a division bench.
And then this there's writ be transferred.
Heard, done it for the parties. Submitted that by the councils of the bar that there is a challenge to the virus of section 168 capital A of the CGST Act. So accordingly, under the High Court rules, matter be listed by the registry before an appropriate division bench.
May I please your lordship? Against my lord, illegal acquisition, my lord, airport road newly to be constructed, my lord. Last 2 times my lord went to time for inspection.
This time we received the instructions, Lordship. Most probably affidavit.
Will be necessary. All right then.
But in these cases, Lordship, the requiring department is Executive Engineer PWD department. We have not yet received that amount which is to be.
Very well.
So it is
You
the,
bring everything on record.
no, Lordship, if we can bring it, Lordship, but that amount has not yet been received by us from PWD department. So if the PWD departments makes the payment, as because the PWD is also the party here, we are only the disbursing authority.
My lord,
So has the land been acquired? Without payment, it can't be acquired.
No, Lordship, land not yet been required, but
We issue notice here, counsel for the parties issue notice returnable 4 weeks. Mr. H. Sharma, additional senior government advocate, appears on behalf of respondent number 1, 7, 8. MSD Hazarika appears for respondent number 5 and 6.
Huh?
Mr. B. Chaudhary for respondent 2, 3, 4. And CGC appears on behalf of the airport authority. Who appears for airport authority? CGC?
PWD পয়সা তো দেবে আমি disburse করব।
Mr. AK Dotto appears for AK Dotto. CGC appears for the airports authority.
Airport authority 9.
Petitioner is agreed. Petitioner apprehends eviction from the land claimed to be under their occupation
Patta land.
Patta land
That's one.
without the proper procedure being
Without
followed.
notice, even.
No, Lordship,
and without
notices
issuance of
were issued, Lordship. Even notification were also issued.
Stop. The petitioners claim that the land is sought to be acquired by without following the prescribed procedure
Even the
under the
calculations were also made, Lord.
under the land under the statute. Stop. Par contra, Mr. Sharma, however, disputes the contention of the petitioner counsel that notices were not issued. He rather submits that even the calculations were made.
And it was placed before the PWD department.
However, he fairly submits that the amount of compensation required to be released to the affected party had not yet been deposited by the PWD department before the state authority. So, parallel notice issue, returnable 4 weeks. Since the respective councils represent the respondent, notices are waived. However, extra copies be furnished within a period of 2 weeks from today. Matter be listed after the returnable date. Issue notice of the interim prayer. Returnable on the same date. Meanwhile, there shall be no eviction of the petitioner without following the prescribed procedure under the relevant statute. Matter be listed again on 29th of January.
May I please, Your Lordship? Lordship, this is a similar case like yesterday, Lordship, connected with the PIL 29 of 2024, Lordship, that lottery matter.
Yes, that is order directing the person to be, I think, to the registry to place it before people. Well, we think like same. Huh? Yes.
I'm obliged, Lordship.
May I please, Your Lordship? Not in this case, we are seeking protection from the police for harvesting the crops, ripened crops. Yesterday morning, my lord, petitioner saw that already respondent has started taking away the ripened crops. Immediately informed the police over telephone police came to the spot and seized the cutting already, my lord, crops, my lord.
Who are the respondents?
Respondents are, my lord, these respondents, my lord, started from, my lord, 5. Respondent number four,
Yes.
yes, four,
Any
4 to
instruction,
12.
Mr.
Lordship,
Sharma?
Lordship, we have received the instructions. It's a dispute between the families, Lordship. Accordingly, a non-FIR, it's a non-cognizable case. Accordingly, non-FIR case is registered. And without the direction of the executive magistrate, we cannot proceed. Accordingly, the same was placed before the executive magistrate, Lordship. So, procedure has already been taken.
You approach the executive magistrate to maintain law and order.
My lord, in the meantime, my lord, we have approached the district magistrate, my lord. Lordship may kindly see. Already we have approached the district magistrate. District magistrate sought police report from the,
Yes, Lordship, that report has already been submitted.
my lord, NXR 5, my lord. Annexure
On
5.
17/12/2024, this report was placed before this.
Now, my lord, as on today, my lord, all the ripened crops have been seized by the police and kept in the custody of the Kamabura.
Hmm. एक मिनट। बरोबर है।
No, sir, what is your prayer now?
Prayer for protection of harvesting, my lord.
How can you
Protection for
protect-
harvesting the product.
No, it can't be that every time you want to harvest, you will do it under police protection.
Only for this time. Already that,
No, that they have already
that
taken.
crop
that-
is in the
That
custody of
they have already taken steps. You have to approach the competent authority for passing necessary orders.
already we have approached, my lord.
Which-
Matter is fixed on 30, my lord.
Which day? Before which
We have
authority?
approached the, my lord, district magistrate, my lord.
Then
There, my lord, matter is fixed on 30. So, my lord, let the matter be fixed after vacation, my lord, so that I can get some
it is
relief.
submitted by the councils of the bar that proper steps have been taken by the jurisdiction and police authorities. And it has been placed before the jurisdictional executive magistrate for passing necessary orders. Stop, Mr. J. Sharma, counsel for the petitioner submits. The matter is fixed on 30.
On 30.
30.
30.
30/12/2024. He therefore submits that the matter be listed in the month of January, by which date they can apprise the court of any such order that may be passed by the executive magistrate according. Let the matter be listed in the month of January on a date to be fixed by the registrar.
Obliged, sir.
May I please, the Lordship? The last occasion we were directed to furnish extra copies to the respondents. We have furnished copies to respondent number 1, 2, 3, 4, and 6, except respondent number 5. He could not be traced out. Okay.
Yes, government, who's there?
14 item number.
Who's for the Information Commission?
Deep duty that matter.
Where is he? He's never available.
That's my knowledge. 40. अपना number. His name is shown, my lord.
His name is Tony.
And causally is
Mr. K.K. Handick, learned counsel, appears for the writ petitioner. MS M. Borman appears for.
I am not there,
Oh,
my
you're
lord.
not
It's
there.
the
Who's
SC
for the
education.
education department?
Education department.
None represents the respondents. It is submitted by the counsel for the petitioner that the information sought for. What is your prayer? What is your prayer?
Yes, Lordship. My prayer is that information sought for is not provided by the particular respondent number 6 and 7, Lordship. Even if
Information sought for by the petitioner has not been provided for by the respondent number 6 and 7.
6 and 7.
You have sought for information from whom?
Actually, Lordship, I have filed up the application before the elementary education. It was forwarded to secondary education. Thereafter, in my second appeal, secondary education was directed by the Commission
All
of
right.
Information.
Since the respondents are not represented, let the Director Elementary Education, namely respondent number 4, ensure that the information sought for by the petitioner is furnished by the respondents number 6 and 7 by the next date fixed. Failure to comply with this order, court may pass consequential orders. Let the matter be listed again on 27th of January. And a copy of this order be placed before the Director Elementary Education by the writ petitioner.
Actually, Lordship, here in this case, the petitioner should have filed an application before the secondary education because it's pertaining to the high school.
Whatever it may be,
Lordship.
since we have made them director, we have asked them. All right? Please take order.
Deeply applied.
But you have to serve a copy before the director.
Lordship. May I please, Lordship? Lordship, on the last occasion, the notice was issued and the extra copy was also furnished to the respondent.
Yes.
Board
of Revenue.
Yes, Lordship.
All right. Then heard learned counsel for the parties issued notice returnable 4 weeks. Respondents 1 and 2 are represented by Ms. G. Hazarika.
I'm one only.
1.
Board of Revenue.
You represent.
Special term take.
All right. 1 is represented by Ms. G. Hazarika.
Myself 3, 4, and 5.
Mr. H. Sharma, additional senior government advocate, represents respondents 3, 4, and 5. Since the respective councils appear for the respondents, notices are waived. Extra copies be furnished within 2 weeks from today. Steps on respondent number 6 by registered post AD as well as by usual course within 2 weeks from today. No notice at this stage is considered necessary to be issued to respondent number 2. Meanwhile, the interim order passed earlier will continue to be in force until further orders.
May it please your Lordship. Lordship, on 17/3/1970, my lord, the father and grandfather of the present petitioners, they have purchased a plot of land of 12 bigha 1 katha 9 lesa, my lord, from one late Krishna Bahadur Chatri, my lord. That is the father and grandfather of respondent number 5 to 12. Then, my lord, by way of an sale deed, my lord, I have annexed that sale deed, my lord, page 19 onwards, my lord. Page 19. There is a sale deed, my lord. And my lord, between Jodu Mohan Das and so and Sri Krishna Bahadur Setri. Thereafter, my lord, the government of Assam, my lord, they have, my lord, planning to acquire the plot of land for extension of second edition of Kaziranga National Park. So, my lord, preliminary inquiry was initiated and subsequently land acquisition proceeding was also initiated and case was registered. And therefore, my lord, though, my lord, by way of a sale deed, my lord, the plot was purchased by our grandfathers and fathers, but, my lord, it has not been mutated in our name. Because, my lord, there is an embargo in the, my lord, as per Assam Land Revenue Regulation, my lord, Chapter 2, my lord, that says, my lord, land exempted from the operation of this chapter. That says, my lord, this chapter shall apply to all land except the following, that is, land included in any forest constituted a reserve forest under the law for the time being in force. Therefore, my lord, in the Jamabandi, my lord, it was named in the name of, my lord, Krishna Bahadur, late Krishna Bahadur Chatri, my lord. That your lordship can see from Annexure 2, page 26. But there is a specific mention, my lord, the entire land is included in addition. Thereafter, my lord, the government of Assam, my lord, on 12/4/2023, my lord, my lord, we have been received, my lord,
You are
4
asking
notices.
for the award. Award has not been supplied to you.
Opium award is not supplied, and we have also not aware
Get
how.
instructions why the copy of the award.
Yes, because of Lordship, my lord, the annexure to the Jamabandi copy. But in the Jamabandi copy, the name of the, my lord, the patadar is, my lord, the Krishna Bahadur Sethi. My lord, they were not being, my lord, mutated their name in the, my lord, their land record. Only because of that, my lord, this process is, my lord, issued a notice to the, my lord, the earlier patadar.
My lord, the 4 notices were issued upon us, my lord. And, my lord,
Where are the notices?
My lord?
Where are the notices?
My lord, it starts from page 40, my lord. Oh, sorry, my lord. It starts from page, my lord, 28.
Annexure 3, Lord.
Annexure 3, page 28, my lord. Sunil Das. My lord. Here, my lord, it has read subject awarding compensation as per the right to fair compensation and transparency in land acquisition.
You have issued notice.
Lordship.
Then?
My lord.
Let me take instruction.
That's right.
My lord, in the meantime, my lord, we may be allowed to, my lord, under protest, my lord, we may be allowed to receive the, my lord, the amount, my lord, which have been issued in our
They have
favor.
to file an application before the deputy collector.
We have submitted our.
No, my lord, there is no representation before the, my lord, the district commissioner. Lord.
No, my lord. Because, my lord, everything is now pending before the subdivisional magistrate, my lord, land revenue, my lord, Bukakhar. We have submitted our application, we have submitted all the detail. And interestingly, my lord, 6 notices were issued, my lord, on the same date against, my lord, that Krishna Bahadur Setri, late Krishna Bahadur Setri. That starts from page 40 onwards, my lord. Page 40, my lord, see, it's Abin Narayan Bamun and Sri Krishna Bahadur Chetri, my lord. Similarly, my lord, page 43 also, Sri Krishna Bahadur Setri. In this way, my lord, 6 notices were issued, my lord. And, my lord, by way of these 6 notices, my lord.
Let him get the instructions. Let him get instructions.
But, my lord, they have already said, my lord, yes, that land has been already sold to our fathers, my lord, by way of an affidavit, my lord. That has already been placed, my lord. At least, my lord,
what is your prayer now?
My lord, we may be allowed to withdraw the amount which have been, my lord.
Which cannot be permitted unless you are satisfied about the award. What is the amount given? You are asking for an award. A copy of the award.
That is true,
has not been given to you.
That is true. But, my lord, under protest we can receive, my lord.
You can receive.
That's why, my lord, only, my lord.
Why, if they have not allowed, why do we want to, why should we issue a direction today? Let him get the instructions. What is the state of affairs before the authorities concerned? Right? Should we issue notice or you'll
No, better issue notice, okay, my lord. I will file, my lord, that response.
No, filing is all right, but they want to receive the amount under protest.
Sorted, my kindly.
Then you obtain the instructions
yes,
without issuing notice. Find out what is the status here. Whether they can be permitted to withdraw. Heard. Mr.
M. Dr.
Learned Counsel for the Petitioner, Mr. J. Hendy. Learned Government Advocate appearing for
2, 3 and
respondent
4.
number 2, 3 and 4. MSG Hazarika for respondent number 1. Stop. The grievance of the petitioner is that the what is that?
My lord, my lord,
Sub-district commissioner,
yes, my lord.
sub-divisional officer. No.
Yes, my lord, now has been called, my lord, sub-district commissioner.
It is not a sub, it should be co-district commission.
Co-district. Which respondent?
Respondent number 3.
It is submitted that the application filed by the petitioners seeking copies of the award granting compensation for land acquired by the respondents are presently pending before the respondent number 3, and the same has not been supplied to the petitioners. So the further prayer of the petitioner is that they should also be permitted to withdraw the compensation amount awarded by the competent authority, but which by the competent authority, under protest. Stop. Before issuing notice, the court would like to direct the respondent authorities to furnish necessary information to the learned government advocate as to why the copies of the award stated to be available with the respondent number 3 has not been furnished to the petitioners as prayed for. The learned government advocate will also obtain instructions as to whether petitioners can be permitted to withdraw the compensation awarded under protest. Matter be listed again on 27 January. And in order to enable the government advocate to obtain instructions, sufficient copies of the writ petition be furnished. List accordingly.
Copy deliver.
Public.
May I please look. Petitioner is a pensioner, my lord. He is getting my lord, about 30,000 per month, my lord. From the his bank account, my lord. Amount has been deducted in the name of tax, my lord. The amount received by the petitioner, which is not under tax, my lord. Amount, my lord, getting as a pension, my lord, which not falls under tax, my lord. He's getting minimum amount, my lord. Can you see, my lord? Page 19, my lord. And operative person, page 21.
Why is it being deducted for income tax of a retired person?
Not if their case is that some amount has been deducted by the bank in the name of income tax TDS.
But he's retired.
He is retired. But why it has been deducted, notice that is not published. While announcement is submitted to one thing, there was some.
Your Lordship, as per section 206 AA of the income tax, any person receiving any income, he has to provide PAN to the bank. In this case, what happened? Till 5th July 2024, his PAN was not upgraded in the GBSS system of the bank, government. For that reason, till 5th July 2024, TDS was deducted from his account. After that, it is not deducted.
After that, not deducted.
No. I have got instruction.
But the amount which was deducted
Yes,
is
ma'am.
entitled to a refund.
It has gone to the income tax, not with us.
He has to file that, what is that form?
26 AS.
206 AA of the income tax.
That he is not amenable to income tax. There is a particular form he has to file it.
So if
Now, Lordship, the bank is deducted and deposited with the income tax. That details may be provided. I'll take up necessary
it
instructions.
is government account, government account.
All right. Heard learned counsel for the parties. Petitioner is agreed by the deduction of an amount from his pension by the respondent bank on the ground that this is on account of income tax deducted at source. The petitioner claims petitioner is about 84 years, who retired from service on 31/7/2000. And because of the purported recovery of tax, deduction of tax, petitioner is suffering huge financial losses. Para. Mr. Parvez, Learned Counsel appearing for the SBI.
No, Punjab National Bank.
Punjab National Bank submits that as per section 206 AA of the Income Tax Act, any amount received in the account, a proportionate amount is to be deducted as taxes, and unless his PAN number is provided. Stop. This PAN number of the writ petitioner was provided only in
Upgraded on 5th July 2024.
5th July 2024.
Upgraded.
Upgraded to 5th July 2024, and thereafter, no deduction on taxes have been made by the bank. Stop. Whatever taxes have been deducted has been transmitted to the concerned jurisdictional income tax department. Stop. Para Mr. SCKL, Learned Standing Counsel Income Tax, submits that he would like to complete his instructions in the matter. Do we issue notice?
Notice we return to issue notice.
All right. Accordingly, let notice issue, returnable 3 weeks. Mr. SCKL appears for respondents number 1, 2, 3.
Yes.
Mr. Parvez appears for
4, 5, and 6.
4, 5, and 6. Since the respondents are represented, notices are waived. However, extra copies be furnished within 2 weeks from today. The respondents may complete their instructions and file necessary affidavit in the matter. Please take over. Yes.
What happened was Stopwatch was issued, my lord. Thereafter, an order was passed. After the substantial amount was dropped, my lord, against the department prepared an appeal, my lord. Lordship may kindly come to page 70, my lord.
Then?
Page 54, my lord. Lordship will see the figures, my lord.
Page?
54.
54. Yes.
Now, my lord, there were total 3 figures, my lord. These all amounts were dropped, my lord. With regard to my lord, first figure, that is, my lord, 3,75,000, my lord. Department preferred an appeal, my lord. The Lordship will find it page 70, my lord.
Yes.
Department was agreed, my lord, with the dropping of this amount, my lord. Therefore, appeal was preferred, my lord. Now, what my lord, appeal authority has done, my lord, he has set aside the entire order, my lord. So there was no prayer for entire order, my lord. And Lordship will see the order, my lord, operating part, Lordship will see at page 97, my lord.
Yes.
And the one, may I read, my lord? In view of above, I consider it appropriate that the evidence submitted by the taxpayer are examined thoroughly by the adjudicating authority, and a region order is issued based on such evidence. Now he is saying that the order is good. Now he is saying I thus set aside the impugned order in original with the direction to the adjudicating authority to pass a fresh order de novo after thorough examination and verification of the documentary evidence, my lord. At one hand, he is saying, my lord, the order is good. And the other hand, my lord, he is setting aside the entire order, my lord.
Go in further appeal.
But my lord, he has no jurisdiction to suo moto enter into this merit of the case, my lord, for which no appeal was preferred, my lord. He has exercised suo moto jurisdiction, my lord.
You go before the appellate authority.
But I am what I am raising is jurisdiction, my lord, because under section 85, my lord, he has no jurisdiction, my lord, to go beyond the appeal, my lord. He can only pass the order confining to the appeal, my lord. Now, my lord, he has
all right.
Out of his own wish, my lord, he is passing the order.
Heard Mr. Gupta, Learned. Misra, Learned Counsel appearing for the petitioner, Mr. SCKL appearing for the GST authorities.
Lordship. Respondent number 2.
Respondent number 2, 3, and 4.
Lordship.
Mr. Toto appears for respondent number 1. Petitioner is agreed by the order passed by the appellate authority at page
79, my lord.
79. dated 29/07/2024, passed by the Commissioner of Appeals. Learned counsel for the petitioner submits that the order in original was passed by the assessing officer. Where is that order?
Page 39, my lord.
No, where is the operative part?
My lord. Your lordship will find, my lord, at page. Miss, my lord, page 63, my lord.
The order in original passed on 6/6/2023 by the additional commissioner, CGST and Central Excise, Guwahati. Confirmed the demand of service tax of rupees 1,21,396, and the penalty was imposed on 1,21,396. However, where is that amount which was set aside, which was not considered? The amount received on this page 56.
My lord.
Page 56.
My lord.
There is an amount of rupees 3,75,07,818, which was sought to be imposed in respect of freight. Page 56 to side. Chart 2, first column. A freight received towards transportation of goods and services where the recipients are factory, company or corporate body, the said demand was dropped. Stop being aggrieved, the revenue one went in appeal before the Commissioner Appeals, who, however, by the impugned order, set aside the entire order. Stop. Learned counsel for the petitioner submits that when the grievance of the revenue was only with respect to one component of the show cause notice, which was dropped by the order, dropped in the order in original. The appellate authority did not have any jurisdiction to pass an order affecting pass an order in respect of matters which were not part of the appeal prepared by the revenue authorities. Being aggrieved, present writ petition has been filed. Mr. KL, standing counsel, EST submits that there is a statutory appeal. The petitioner is required to prefer the appeal, and there is no explanation as to why the petitioner has not approached the authority prescribed under the Act, namely the sestet. Let notice issue, returnable 4 weeks. Since the respondents are represented, notices are waived, extra copies be furnished within a period of 1 week from today. Question of maintainability of the writ petition is kept open. Matter be listed on 27th of January. Impugned order shall remain state in the next 8 weeks.
Here, Lordship, nothing has been demanded. Only the order has been set aside and it is remanded back to the.
But they have been asked to proceed in the matter.
That order may pass. Stay with that will create the confusion. Lord.
Why?
Because Lordship, nothing, no demand is there till date. Only matter has been remanded back to the original authority for de novo proceeding.
That's right. So if the appellate order is stayed, de novo proceeding is stayed.
No, Lordship, here one thing, Lordship, the submission of our learned is that some demand was dropped, and the department preferred an appeal with respect to 3,75 crore. That extent, if they admits that amount, then they have to deposit that amount. Rest of them may be state that.
I have not challenged the order in original. I am abiding by the order. Their demand of 1,21 that I will pay.
Only the de novo has been stayed. But by the appellate authority, they have interfered with the order, entire order.
Yes, that they cannot accept in the.
Therefore, they've asked for de novo proceeding. So if you don't stay the order, de novo proceedings will commence.
Well, 19 and 20 relate to DRC 01. No so-called was issued, my lord, only DRC was issued, my lord. Lordship has already passed similar orders.
Well, let it, at least one date may be given.
Yes,
to me.
yes.
To happen. I know.
Matter be listed on
Any day, my lord, immediately after.
on 6th of January.
Lordship.
On which date the Standing Council GST will obtain necessary instructions.
Deeply obliged, my lord.
Extra copies be furnished by the council to the petitioner to enable the Standing Council to obtain the necessary instructions. Yes.
Please, your lordship. The matter relates to the denial of the registration of my land by the sub-register at Borpeta. My lord, in fact, my lord, my son is studying at the Nerim at Guwahati, where every installment is 90,000, my lord. And my lord, I have obtained permission from the Deputy Commissioner, no objection. Then the Development Authority of Borpeta. Then accordingly, I have purchased the cell deed. And I have submitted the cell deed also before the register, that is the acknowledgement. But even then, they are not affecting the registration. That's why I am before your lordship.
Let me take instruction.
Heard Mr. S.C. Dispatch, counsel for the petitioner, who's before this court seeking an order against the respondents in view of the fact that you want to sell.
Yes, because of the education expenditure of my son.
In view of the respondent authorities, more particularly respondent 3 and 4, refusing to register the sale deed for sale of the land, plot of land owned by the petitioner. Stop. Para Mr. J. Hendrick, appearing for the respondent number
3 and 4 lawsuits.
3 and 4 submits that he would like to obtain instruction in the matter. MSG Hazarika appears for respondent 1.
1 and 2.
1 and 2. Let the standing councils obtain their required instructions. Extra copies of the writ petition be furnished within 2 weeks from today.
May I pray the pendency of the petition shall not be barred
Pendency of the writ petition shall not be a bar to
registration of the
to register the to proceed for registration of the sale deed by the writ petitioner. List
next item we also say, my lord,
list on
that is relates to treatment of the petitioner, my lord.
list on 10th
Yes.
January. The similar orders. Both the matter. 21, 20.
Oh, 22 to again, no?
Yes.
Yes.
Yes, exception was sought for in this case. PWD.
Yes, PWD.
He was there, my lord. He has
Where is
received
Mr. B. Chaudhary?
He has informed me he has received some instruction, my lord.
Where is he?
After some time, my
Please inform. After a while.
Lordship, in this case, I was supposed to obtain instruction. I informed them they could not correlate the challan submitted by the petitioner, Lordship. So I required maybe taken on 6th of January, Lordship.
Mr. SCKL, counsel for the respondent, prays for further time. Mr. Misra, learned counsel for the petitioner, does not object to the prayer made. This the matter again as agreed to on 6th of January.
Lots.
6th.
Lots.
6th of January.
But in this case, the registration of the petitioner was cancelled. Lordship directed me to obtain instruction. I talked to the commissioner. Lordship, he said that they are not in position to restore unless the court passes an order. And Lordship, here in 2020, his registration was cancelled. He did not prepare any appeal, neither he filed an application for restoration of the.
My lord, if today it is restored, my lord,
it will not no prejudice the government, my lord. Rather, I will, if today it is restored, my lord, it will not prejudice the government, my lord. Rather, I will be filing appeal from 20 till 24, my lord. And government will getting, my lord, all the late fees and revenues, whatever there. And lordship, then, my lord, I will.
No, see, we permitted all this during COVID. It's a different situation.
It was cancelled COVID only, my lord.
No, but then you waited for so long. Why?
Because of during COVID, my lord, he suffered huge losses.
COVID was over by end of 21 or 22. Then
Definitely, my lord. At that time, he was suffered huge loss, my lord. Subsequently, he has recovered and he has updated all his return, my lord. And lordship, if lordship restore it, my lord, it will not prejudice the government, my lord. Is the issue involved, my lord. They will not
but
prejudice.
there is a mandate of the act
My lord.
that if you don't, then it gets automatically cancelled.
That is true, my lord. That's why there was a default on the petition's part. That's why it is default. But lordship, civil order is in passed, my lord, by lordship also, my lord, directing them to restore.
Can an application be filed before the central board?
Not, but say in the what happened in the meantime, amnesty scheme was floated to restore the.
He did not apply there.
He did not apply.
Because my return was not updated. Recently, I have updated my return, my lord. At that point of time, my lord, because of
Why have you not done it?
because of my financial difficulties, I could not.
Now, what benefit are you likely to get after 4 years?
Now, my lord, I am trying to participate in different works, my lord.
You go for fresh registration.
My lord, with all my department, my lord, his registration, I will enroll with this registration, my lord. Now I have to change everywhere, my lord.
That is your
Even
concern.
bank, if lordship
That is your concern.
No,
What other benefits are you entitled to get by restoring your registration, which was cancelled in 2020? It's only the ITC at best.
No, my lord, but my lord, in during this period, I have not done any business of ITC. But lordship will see. And
Then how are you prejudiced?
No.
How are you prejudiced going for a fresh registration?
Because with all my departments, I have this registration are with them, my lord.
That is not a ground.
My lord.
That is not a ground.
My lord.
I can understand that you have sufficient credit at your disposal, which because of whatever reason you could not avail. If you have not done any business, then where is the question of going back? Mainly because it causes difficulty in your registration.
Lordship also see the order, my lord.
You file the amended application before the
Lordship also
department.
see the order, my lord. The order page 28, my lord. The reason, what is the reason given, my lord, by them, my lord?
Whatever it may be, then we'll issue notice here.
But then
Let us hear.
lordship, but fix it in the, my lord, after vacation, my lord.
No, after vacation
I
only
will
it
just
will come.
I will obtain instruction, my lord, what difficulty he will be facing if not restored, my lord. Exact written instruction, my lord.
You have the instructions, you did not do any business.
ITC, I have checked up. I have not checked up every year if any pending ITC is there or not.
Even if it is there, it is gone.
My lord.
They will catch up and put you behind bars.
But lordship will see. Lordship has passed earlier orders, my lord, directing the restore, my lord.
Matter be listed in the month of January. 10th January.
My lord.
Enabling the counsel for the petitioner to complete his instructions
My lord.
in the matter.
Much pleasure, lord.
Yes.
Lordship, may kindly go through the order dated 16/12.
Any information?
Lordship, I received one instruction in the particular, when the lordship has the other test map, but you kindly go to the.
Who is the petitioner?
Halema.
What is your DAG number, Pata number?
My DAG number is
2625.
384 old 4108 new. And KP Patta number 587 old 2625 new.
what is this, in the cause title you have filed some representation to stop mutation permission in respect of a plot of land.
In respect of a plot of land, lordship, to the other co-pattadars, lordship, as because I am the patta holder of this plot of land, lordship.
That is
Then
your claim,
other,
but the circle officer's report says otherwise.
lordship, I'm not aware about the. My case is that, lordship, that plot of land does not have any road,
You
lordship.
have to bring it on record.
Lordship, may I kindly go to the trace map?
Yes.
Then in the trace map, Lordship, the number 299, the little on the portion was the red mark, my lord, 299. This is the, my lord, land used by the other people, my lord, that pattadars, those who are.
That red portion is belonging to whom?
My lord, that bigger one is belong to the petitioner, and the smaller one also
No,
with
no,
the
the
petitioner.
red one.
Lordship.
Whose plot of land is this?
It is a petitioner, Lord.
Petitioner.
Then
On the left hand side, that
there is a
small,
little bit, my lord, that road was used by the other person, my lord. That was blocked.
For a
Only that
moment,
portion,
lordship,
lordship.
even if, lordship, for argument's sake, I suppose, lordship, I allowed them to, lordship, use that plot of land. Now I am denying. For that, they have to obtain a declaration to use that as a public path, lordship. This is my Miyadi land, lordship. This is my boundary of my Assam tribe house, lordship. And all the three
what is this 298, 294 stretch of land?
294.
On the top.
294. This
appears to be a road.
Road, lordship.
So
This is a road.
So this road is there, which connects 297.
297.
Now this particular stretch of road,
lordship,
which the petitioners are opposing, is ingress and egress to which plot of land?
My lord,
297.
297.
But 297 already has a road.
My lord, that there is another road side, lordship. This side is lordship. The right hand side is the block, and the left hand side, my lord, that small portion, lordship, 299.
But there is a road, so you have to tell us why this road cannot be used for
My lord, that
ingress and-
297 person they cannot go, my lord. The other.
Why?
Places. My lord,
Why?
this road was, my lord, blocked now.
No, this road is by the side of his plot of land.
Lordship.
So he can have ingress and egress to that road. Why can he not do it? Is there a, what is there?
Whether there is any alternative road is there, my lord, that is not in clear in the picture.
So you find out in respect of 294.
294. 297. 290.
290, no, 294 is the stretch of land. And 297 is the plot of land. Whether this 294 ingress and egress can be made through the stretch of land at 294, which is shown to be a road. All right, heard learned counsel for the parties. Mr. J. Hendick, learned Brahmin advocate, has produced a copy of the communication dated 16/12/2024, received from the office of the Central Officer, Guwahati Revenue Circle, Kamrup Metro, to submit that which encloses a trace map. So, referring to the trace map, learned Brahmin advocate submits before the court that the stretch of land in question through which the road is sought to be made is reflected in the stress map, and if it is permitted, there shall be no hindrance or difficulty caused to the petitioner who is in possession of the land and in whose name the land is mutated. Stop. Par contra, MS R. Chaudhary, learned counsel appearing for the petitioner, submits that there is no dispute that the land is mutated in the name of the petitioner, and if any road is sought to be claimed over the said plot of land, then proper orders from a court of competent jurisdiction needs to be obtained by the private respondent or by the government, and by payment of necessary compensation if required. So, Hera, upon a perusal of the communication as well as the trace map at close to the said communication, it is seen that the dispute is with regard to ingress and egress to a plot of land shown in the trace map as tag number 297, which is an adjacent tag of the land claimed to be mutated in the name of the writ petitioner, covered by tag number. What is your tag number? 299.
384 old and 4108 new.
4108. Okay, 4108 within bracket new. Tag number 4108 of new. Stop. The trace map also reflects a stretch of land covered by tag number 294, which appears to the court to be land used / kept as access road for plots covered by tag number 296, 295, 309, 310, 308, 309, and 297. Stop. On a query made by the court, the learned government advocate, however, submits fairly that the communication received from the office of the circle officer does not clarify on this part. He therefore submits that further instructions are necessary on this aspect. Accordingly, matter be listed again on 27th of January. Interim order passed will continue till the next date fixed. We'll give it back or we keep this.
I have a.
You take the original, give us the copy. Copy of the instructions placed before the court by the learned government advocate is kept in the case report.
In this matter, Lordship, notice has not yet been issued.
We are not issuing notice at this stage.
Obliged.
Here.
Please, Your Lordship. Lordship, Mr. D. Gogo is the engaged counsel. Due to some reason, he could not reach the court by now. So, Lordship, I pray that Your Lordship fixes it at 2 p.m., Your Lordship.
2 p.m. So we'll have it tomorrow. Tomorrow. Matter will be listed tomorrow at the request of counsel appearing for the response.
Obliged.
Obliged. Yes.
May it please your lordship. My lord, the matter relates to, my lord, without issuing suppose notice in the subsection 1 of section 73, order under section 73 has been passed. A similar matter came up before this honorable court, and this honorable court in my lord has passed the order
On 6-1, my lord, regarding that, my lord.
6-1. All right. There are several matters fixed on 6-1. Heard learned counsel for the parties. Petitioner has put to challenge the impugned order dated 14/12/2023, stated to be passed, stated to be issued by the respondent number 3 under section 73, the Assam Goods and Service Tax Act 2017. Stop. The grievance of the petitioner is that the impugned order was issued without prior notice without issuance of any prior show cause notice. Stop. Para Mr. B. Gogoi, learned Standing Council Goods and Service Tax Department, submits that similar matters are fixed on 6th of January. Accordingly, let the matter also be listed on 6th of January. The petitioner will furnish extra copies during the course of the day to the Standing Council to complete his instruction. Will do. List accordingly.
पहली परसों को तो ऊपर टाइम बिंग मतलब टाइम
What time being? All right, time being.
My lord, impugn order contained page 52. My lord, I am the bona fide owner of the plot of land. Because only a pendency of that, my lord, appeal, where there is no stay order, my lord, my sale permission was, my lord, rejected by a person who is otherwise not, my lord, competent to reject my application. Page 52.
52. Yes.
Lordship, they have also some notification, and the power has to be accepted by the collector, not by the circle officer. Lordship, my prayer is that at this stage, Lordship, I direct them to get the instruction under which provision of law, my lord. My application has been rejected.
Yes, then we'll have to issue notice at this stage.
My lord, Lordship, only humble prayer. Let them get the instruction. Suppose that instruction is sufficient, my lord. My lord, my purpose will be served, my lord.
Heard Mr. S. Samaria, learned counsel to the petitioner. Also heard MS MR PR Monto for respondent number 1, MS Moore for respondent 2 and 3. The petitioner is aggrieved by the communication dated 12/12/2024, whereby the circle officer, Sonapur Revenue Circle, informed the petitioner that her application seeking registration for, you want to buy or sell?
My lord, I want to sell.
Selling of a plot of land has been rejected in view of case number Miss Appeal number 42 of 2024 pending before the court of the learned district judge, Kamrup Metro. Stop. Learned counsel for the petitioner submits that the dispute in this matter pertains to some other person where the petitioner is not
No
involved.
stage there.
But what is the appeal about? What is that?
Appeal, my lord, the other side has challenged my sale deed, my lord.
Huh?
The other side has challenged my sale deed.
Huh.
Now, against the sale deed, my lord, there is no stay order. That proceeding is, my lord.
Then how can he pass an order for
My lord,
granting
section
permission?
52 pendant right, my lord, transfer TP Act allowed, my lord.
So appeal is against you.
Appeal, I have filed because I have filed an application there, order 7 rule 11, my lord, for rejection of plate.
You write it that the circle officer has rejected on the ground on the ground of pendency of Miss Appeal number so and so before the district judge, Kamrup. So grievance of the counsel for the petitioner submits that there is no injunction order passed by the appellate authority, and therefore, under the provisions of the Transfer of Property Act, there is no bar for registration of the sale deed, pendant deed. Stop. Para, considering the issues involved, issue notice returnable 3 weeks, 4 weeks, since the councils are represented. The notices are waived, extra copies be furnished within a period of 2 weeks from today. Respondents may complete their instructions and file necessary affidavit if so advised in the meantime.
My lord, eventually in this case, appeal not lies, my lord. So far my case is concerned, my lord, the father of the petitioner name appeared in the year 1962. That is lordship page 14. And now by challenging this entry, after long gaps, the respondent number 5 to 7 filed this miscase matter on 10/1/2022. That is Lordship page 29. And for cancellation of this my entry. And in this miscase, there is no any order challenge, my lord. Whether the order passed by additional assistant commissioner or extra assistant commissioner or subdivision officer. And what has happened, my lord, the respondent number 3, that miscase has been treated as revenue appeal under section 147, section 151, my lord. But so far, my lord, section 147 of this Assam Land Revenue Regulation 1886 says that appeal lies to the Deputy Commissioner from order passed by the subdivision officer, an assistant commissioner or extra assistant commissioner. But in a wrong proceeding, my lord, this appeal has been maintained, and now this impugn order passed.
So go and appeal, further appeal before the revenue board.
But eventually this appeal is not maintainable. This is wrong proceeding, my lord. This is the impugn order, my lord.
Who has filed this appeal?
Appeal filed by actually miscase filed by respondent 5 to 7. This respondent 5, 6, and 7 filed this miscase. And miscase has been treated as revenue appeal. Otherwise, the appeal does not lie. Because this miscase has not assailing any order passed by the subordinate officer of the.
So therefore, you should go before the revenue board.
But I am not.
You are agreed by this.
Because
you are agreed by this order.
Because so far this order, this is a wrong proceeding, wrong order passed, my lord. Eventually, appeal does not lie.
How are you agreed by this order?
Because my father's name has been deleted by your order. And if the party agree, then they have to file civil suit after 65 years later. My father's name entered in the year 1962.
No, but whether this order was passed correctly, incorrectly, can be examined by the revenue board.
No. Actually, my lord, if the order passed by deputy commissioner, then they approach before the revenue board. And if the subdivision officer pass order or assistant commissioner pass order, then
this is by
they can
this is by additional deputy commissioner. Additional deputy commissioner.
No. This order passed by additional deputy commissioner.
Right.
Because on behalf of the deputy commissioner, petition this miscase approach before the district commissioner, page 29, and this order passed by additional deputy commissioner.
Therefore, go and appeal before the revenue board.
But this appeal is not maintainable.
Challenge it before the revenue board.
But question is whether this order passed and treated as revenue appeal, how revenue appeal can lie? Well, kindly have a look, my lord. This is for section 147, my lord. For a moment, my lord. 147. 147 says when appeal lies. Because they prefer appeal.
Where is the appeal? Where is the appeal memo?
This is the miscase eventually, my lord. That is page, my lord, 29.
29.
And it has maintained as miscase number 2/2023. And the content of this miscase, there is no any whisper against any order passed by the deputy commissioner or assistant deputy commissioner, nothing else. Thus saying the cancellation of the entry. The cancellation of entry cannot lie revenue appeal. And so Lordship 147 says, my lord, 147 subsection A says that to the board from orders, original or appellate passed by a deputy commissioner, settlement officer or survey officer. That has not been attracted in this case. Now B saying but to the deputy commissioner from order passed by subdivisional officer, an assistant commissioner or extra assistant commissioner, then it is also not attracted. So how it can be treated as revenue appeal under section 147? So the miscase addressed to the deputy commissioner, and it cannot be treated as revenue appeal under section 147B. because 147B is not accepted here. No any order essay of passed by subdivisional officer or assistant commissioner or extra assistant commissioner. This was the entry in the year 1962. And within 90
No,
days.
this is in respect of the appeal is filed challenging the mutation, isn't it?
No.
Now, the mutation order is passed by whom? By the circle officer.
But here, by law, so far section 147B is concerned, the subdivisional officer or assistant commissioner or extra commissioner. But appeal, there is a limitation. It was in the year 1962.
Therefore, you should carry this before the revenue board.
The question is, my lord, whether this appeal is maintained, whether the deputy commissioner initiated this case in a wrong manner or right manner. If right manner, then I have to approach before the revenue board. But it's wrong, and the proceeding is wrong.
We'll have to examine it, but we are not inclined to grant you any interim order.
Notice me.
Heard Mr. K. Bhuya, counsel for the petitioner. MS P.R. Monroe for respondent number 1. MS Kumar for respondent 2, 3, 4. Steps on respondent 5, 6, and 7 by registered post 80, as well as by usual course within 1 week from today. Since the respondents 1, 2, 3, 4 are represented by the respective counsels, notices are waived, extra copies be furnished within a period of 1 week from today. Petitioner is put to challenge the order dated 7/10/2024 passed in RA case number 02 of 2022-23. Stop counsel for the petitioner submits that this order could not have been passed by the additional Deputy Commissioner Borbeta by treating it to be a revenue appeal, as this order is on the basis of a missed case filed by the respondent, private respondents, seeking correction of the mutation order.
Cancellation of the
and praying for cancellation of the same. Let the respondents complete their instructions and file necessary affidavit in the meantime. Notice on the interim prayer. Returnable on the
Lordship, one thing maybe the impugn order shall be outcome of this subject to outcome.
All right. Let me write impugned order passed by the revenue appeal shall be subject to the outcome of the writ petition.
Hello. Hello.
May I appeal? Lord, we have challenged the Lord notification that your Lordship will find at page 22.
These matters are fixed on
9th of January.
9th of
Now, my lord, problem is there, my lord, on 28th of this month, my lord, the final voter list will be published.
We'll consider that. We have issued some orders yesterday. This matter pertains to the challenge of the delimitation of the Panchayat wards. Similar matters are fixed on 9th of January. Let this writ petition also be listed on 9th of January along with WPC. What is the...
Now, my lord, 5346, one of the case, my lord.
No, no. এই কালি আপনার এই HR চৌধুরী কেপি পাঠক HR চৌধুরী ম্যাটারও নাম্বারটা দিয়ে দিন। All right. Please speak so and so.
Obliging.
Should we issue notice here?
Yes, sir.
All right, then issue notice returnable on 9th. Mr. K. Kumar represents 1, 2, 3, 1, 2, 3. Sorry, 1, 2.
1, 2, 4, 6, 7, 8.
4, 6, 7, 8. Mr. Dubey appears for respondent number 3. And
3 and 5.
3 and 5. And who appears for 8? PDO?
I'm appearing.
You're appearing.
Yes,
okay. Since the councils represent the respondents, notices are waived, extra copies be furnished within a period of 1 week from today.
Some protection may be given as.
We had already issued some yesterday.
Oblige. Oblige.
Sorry, Lordship, I couldn't appear.
Any
Sorry, Lordship, I couldn't appear. That,
for ASTC?
Yes, Lordship.
Get your instructions if there is
Yes,
anything. Mr. C. Sharma, Learned Standing Council, AST, will obtain instructions in the matter. Place this matter again on 20. MSSB. SB Chaudhary appears. MS Borman, you are also appearing?
No, but yeah.
Extra copies be furnished within the course of the week on the state respondents. They say there is no structure on that land. You say that some shops and everything are running.
It is there, my lord.
They say it is not there.
Let them file short affidavit, my lord, on the, I can file response.
Mr. P. Chaudhary, Learned Standing Council PWD, has placed copy of the instructions received, which reflects that as per the PWD department, there was no permanent/temporary structure on the said location of the river Gorang when the construction of the bridge had started. Stop. Learned Counsel for the petitioner, however, strongly disputes the same and submits that he would like to bring on record the materials in support of his contentions by filing a short affidavit. Let the matter be listed after 2 weeks.
If the construction was not there at the time of construction of the bridge of the house, it has come into existence only after construction of the bridge.
You right, Mr. P. Chaudhary. P. Chaudhary, P. Chaudhary submits that the temporary sheds, if any, have come only after construction of the construction was initiated. Therefore, the petitioner is not entitled to claim any compensation or zirat in respect of this. Structures.
Interim order is there.
Interim order passed earlier. We'll continue until further order.
Lordship, I beg to appear virtually in item 30, Lordships.
Yes.
Lordship, this is the matter regarding Lordship 70 for GST. The due date to issue show cause notice for 2021 financial year was as per the statute 28.
No, we are not taking up your matter. It's
13
some other matter. This is item number 32.
32.
Oh, I apologize. I apologize.
Yes.
Yeah, that's. Eviction notice, your lordship, page 40. Your lordship. Page 40 Barnicola, your lordship.
40.
Page 38, your lordship.
Huh?
Eviction notice, your lordship. I challenge eviction notice. Page 40 is the Barnicola and type 2 is 38. Out of 13, 6 petitioners before your lordship. They are residing the government land for last more than 15 years. In the notice, nothing has shown why they are evicted there, not the reserve land, nor the your lordship, wetland or roadside land. In the notice, your lordship, it shows 55 bighas of land, and they are holding, your lordship, they are occupying only 5 bighas of land. I have details I have given in page 3. And your lordship, on to page 15.
Yes, revenue. Our government.
Instruction required.
No ground has shown why they are evicted.
Heard learned counsel for the parties. The petitioner is aggrieved by the notice dated 11 December 2024, issued by Circle Officer Matia, Revenue Circle.
Sorry for your interruption. The petitioner number 6,
Hmm.
his name is not there in the notice.
No, your lordship, no, your. His father is the son of Gofur Ali. Gofur Ali expired. That's why I'm. Now he's.
Where is Gopur?
The petitioners are aggrieved by the state notice, whereby they notice served by the circle officer, whereby they have been asked to vacate the premises and hand over possession. Stop. The tag numbers of the plots are mentioned in the state notice. Stop. Learned counsel for the petitioner submits that these are what? Government land.
Government land. That is why 18.3 notice.
That the petitioners have been in possession of the state land, and the state, the respondents cannot evict the petitioners without following the due process of law. If it is a government land, then what is your problem here?
Problem is there you are. Your lordship, were applied for settlement also.
You may have applied for, that will be considered. It's not your Miadi land.
No, no.
Then the procedure prescribed will be followed.
Yes, Lord.
You'll be your cases, if you are found to be a landless person, then
landless people. Landless, you are reverted. We
right. Petitioner claims to be a landless person.
Landless,
therefore, evicting him at this stage from the plot of land without giving alternatives suitable plot will cause grave prejudice to the petitioner. Stop para Mr. H. Sharma, learned senior government advocate representing the respondents. Respondents 2 and 3 submit that there is no dispute that the land in which the petitioners are presently land which is under the occupation of the petitioner is a government land, and in spite of that, the department has proceeded to issue a notice under regulation 18.3. Stop. Under such circumstances, petitioners cannot claim any right save and except their cases to be considered for resettlement as per the
prescribed procedure.
What is that?
It can be
as per the procedure prescribed under the
applied method. Hurry up. Page 37.
as per the procedure prescribed under the what is the name of that act? Rehabilitation and resettlement of
A land policy of 1919, Lordship. Oh, sorry, 2019.
Right, as per the provisions prescribed under the right to fair compensation, transparency in land acquisition, rehabilitation, Resettlement Act 2013, read with the land policy, state land
Of
policy
2019,
of
2019.
2019. Stop. It is seen where, having heard learned counsels for the parties and also from the petition enclosed, documents enclosed to the petition, it is seen that necessary applications have been filed before the authority for settlement of costs and sealing surplus land, and which have been received by the Department of Revenue Department. Stop. Under such circumstances, this court is of the view that the writ petition can be closed with a direction to the respondent authority to take all steps prescribed under the Act of 2013, read with the land policy of 2019, to ensure that the petitioners are rehabilitated to an alternative suitable plot of land pursuant to their eviction from the present plot of land in pursuance to the notice dated 11 December 2024. Stop. The writ petition accordingly stands disposed of.
It's no coercion in this notice.
No coercing. We have already directed that we will take care of your interests. Otherwise, no eviction. If you are occupying government land, and since when did you apply? Since when are you occupying the government land?
The last 15 years we have.
That is the statement.
15 years.
More than 15.
But you have applied only in 23.
Lordship, because Vasundhara. There is one document that there, 89, some other also document that from 1989.
But you have not applied for that. You have to apply for settlement.
Regarding the 2013 Act, Lordship, that is the fair compensation, regarding the fair compensation.
Yeah, whatever, but resettlement is also there. There is a resettlement policy required to be framed
Yes,
under
that
this Act.
resettlement, yes, that policy is under that notification of 2019. Under that, most probably my learned friend has already applied.
So we'll give a direction to the authorities to dispose of their claims within a time-bound period.
Yes, Lordship, that 300 days time is there, Lordship. If they may prefer, if your Lordship comes to page 37, it's a
yes.
Shall be provided within 300 days. You may raise an appeal at so and so, if not delivered within that 300. That handle is with them, Lord.
All right. Disposed.
Much.
Yes.
Lordship, I appear virtually for item 13, Lordship.
Yes.
Lordship, here, Lordship, we had challenged a show cause notice as it was beyond the jurisdiction because, Lordship, under section 7310.
Who's for the respondent here? GST.
Lordship, GST, Lordship, on 13th
Here,
of December.
Where's Mr. B. Gogoi?
He had appeared and sought time for instructions, Lordship.
Where's Mr. B. Gogoi? Yes, you are agreed by?
Lordship, the show cause notice at page number 49, Lordships. Lordship,
Yes.
I'll just take two dates are important in this matter. Section 73, subsection 10 of the CGST Act provides for time limits to pass an order for a financial year. That is linked with, Lordship, the due date of annual return. I have extracted the provisions, Lordship, that is at page number 9 of the writ petition, Lordship.
You have not responded to the show cause.
Lordship, it's barred by jurisdiction itself. It's barred by jurisdiction, Lordship, because the due date to issue the show cause was 28th.
Why don't you take it up before the authority is concerned?
Lordship, jurisdictional issues cannot be taken up by the authority because authority itself has issued the show cause assuming incorrect jurisdiction.
No, but we're not inclined to stay a show cause notice.
Lordship, kindly sees what is the prayer, Lordship.
All right, heard learned counsel for the petitioner. Petitioner is agreed by the show cause notice dated 29/11/2024 issued by the Assistant Commissioner of State Tax Jorhat 1. Stop. The counsel for the petitioner submits that the show cause notice is time barred and could not have been issued by the authorities concerned, and therefore the concerned officer, concerned authority does not have the jurisdiction. Consequently, he is before this court. On the last date, the State Council was permitted to complete his instructions. Stop. Today, when the matter is called, the State Council is not available. Accordingly, let notice issue, returnable 3 weeks. The petitioner will take steps, service of extra copies on the State Council within 1 week from today. Respondent will file the necessary affidavit in the matter. Issue notice on the interim prayer, returnable on 20/20.
Lordship, the due date to file reply will go, Lordship, may kindly to that extent may say I will file a reply, but no courses, no order can be passed. At least, Lordship, otherwise my writ becomes infructuous. I will file a reply to the show cause on merits to the department, but no order to be passed.
When is the date? When is
Lordship,
the date?
Lordship, kindly takes page number 50. In the table, the due date is 29th of December 24. I will file the reply, Lordship, but till your Lordships take up the matter on jurisdiction issue, no orders to be passed, Lordships.
May I please, your Lordship? My Lord, in this matter, we have communicated with the department. Our instructions have been awaited, my Lord.
That's right. So we are issuing notice. The petitioner submits that the next date fixed in the show cause is 29th.
The due date to file reply is 29th, Lordship. The hearing was on 18th, which
reply is 29th of December 2024. Accordingly, then we'll give you an early date. Let the matter be listed on 10th of January. 10th of January, pray for interim to be considered on 10th of January.
Lordship, kindly restrict them to pass an order, Lordship. They will pass an order. Lordship, kindly restrict them to pass an adjudication order. I will file my reply.
You file necessary applications before the authority. That's all.
Lordship, authority has issued a show cause. I will file a reply. But if they pass an order, this writ becomes infructuous.
We'll see about that, Mr. Counsel. We have issued a notice on the interim prayer.
Lordship, kindly
we'll consider
your
matter. We'll consider your matter on that date.
Get it. Much of
Yes.
May I please, your Lordship? My Lordship, kindly see order dated 20/11/2024. Lordship pass order.
Yes.
Then they have filed affidavit. In the affidavit, my Lord, they have.
So why is it for orders?
Orders. We have taken steps, my Lord, upon the respondent.
So let it come for admission. Let it come for admission.
Lordship, but only thing is that my Lordship has already indicated to consider my interim order after filing of the affidavit. But they have filed the affidavit, my Lord. My limited prayer is that in total violation of the Assam Panchayat Act 1994, my Lord, MLA has given some notes, and on that basis, my Lord, the elected body has deprived the elected body from approving the list by the DPC, my Lord. And they are now going to execute.
Should require some hearing.
Require, my Lord.
That's
but
right.
at this stage, my Lord, status quo to be maintained, my Lord.
Yes.
Lordship, we have filed our affidavit.
Status quo with regards to the, my Lord. The precedent is before your lordship, my lord. And 126 of the Assam Panchayat there is specifically prescribed a procedure to be submitted by the Gausabha.
What is there in the affidavit?
Kindly see
Kindly see.
page 60.
Page number 62, Lordship in our affidavit. Para 4. That the submissions made in paragraph 14 being matters of records of the case, your deponent does not admit any statement made therein which are contrary to and or inconsistent with what appears from the said records. It may be mentioned that it is true that the Sargola GP authority submitted the action plan for the year 2021-22, 2022-23, and action plan 2021-22.
All right, matter be listed on 27th of January.
But they have admitted, my lord.
Meanwhile, what is that action plan?
Action plan.
Action plan for the 15th. What is FC?
15 finance commission. 15 finance commission. For the year, my lord, 23, 22, 21, 22,
for the year 2021-22 and 2023-24 shall be subject to the outcome of the petition. List on 27th.
My lord, they are going to execute it.
Subject to the outcome of the petition. If required, we'll pass orders on that.
If they, my lord, then
if they proceed, they proceed. It will be subject. If we find that no, it was not.
They have admitted in their affidavit.
If we find that it is not as per the procedure of law, then we'll interfere with that. We are making it subject. These are developmental works.
Yes, ma'am.
Putting a status quo.
But I have being on record that, my lord, MLA's request, my lord. He is not the authority, my lord, under the Act. Under the Act, it is the Gausabha to proceed.
Therefore, we have made it subject to the outcome of the writ petition.
My limited prayer is the status quo till date next date.
No.
With regards to
no status quo on this work.
It's
It's a developmental work at whosever instance. Let us say it is at the instance of a person not authorized.
Yes, ma'am.
But it is for the benefit of the residents of the
Yes,
government.
true, my lord. But
how does it affect you?
But this Act prescribed to approve this.
How does it affect you as the president?
My lord,
if it is for the betterment of your.
My lord, he's the representative of the people. He has commitment to the people, my lord.
No, commitment is okay, but commitment is for development.
Yes, but
now if the development works are carried on.
Yes, ma'am.
How does it affect you?
But
it may not be as per the rules, regulations, then consequences will follow against the persons who has carried out the work. Let us say there is a budget provision.
Yes, ma'am.
And they go beyond the budget.
That observation may be there. If they proceed with the work, my lord, necessary action will be taken. That observation may be.
We have already said it will be subject to the outcome of the writ petition.
They should not proceed in violation of the.
What work? Tell me, what work is this? What work are you concerned about? What work?
Developmental work.
Then, for whose development? Development of the residents of that. So why are you stopping that?
But in violation of
it may not be through you as you want. It may be through somebody else.
As the Act wants.
All right, as the Act wants. But if they have done something unauthorized, then consequences against them will follow. That is why we say subject to the outcome of the writ petition.
Obligation.
Your Lordship, I am appearing on behalf of the writ petitioner. Your Lordship.
Why is it for orders?
My lord, we have filed a stay vacating application, my lord. My lord, I've been led by Mr. Senior Advocate Kane Chaudhary, my lord. So my lord may, if permit, may take up the matter at 2 because the stay that's operating, that is disturbing the entire school premises, my lord.
We can only issue notice today.
No, my lord, notice has already been issued in the IA, my lord.
No.
Yes, my lord. On the last occasion, the notice
3662.
Yes, my lord.
3662.
Your Lordship, we will file reply objection to this IA. So we need some time.
3662, no notice is issued.
On the last occasion.
We don't see any notice. Notice is issued in the writ petition.
Is my lord 3662, my lord.
3662, no notice is issued. This has come for the first time.
It has come for the second time. Maybe, my lord, there's some error on my part. My lord, in that fact, my notice will be issued, then I'll take
Right, we'll issue notice. Right. This is filed by you.
Yes, my lord.
Mr. S.P. Sharma, learned counsel for the applicant, seeking vacating modification of the order dated 4/10.
Yes, my lord.
2024, passed in the accompanying writ petition WPC 5261 of 2024. Mr. B.J. Talukar, assisted by Mr. Mehdi, appears for respondent number 1 and 2. 1 and 2. Mr. P. Nayak appears for respondent number 3, 4, 5, 6.
Yeah.
Steps on respondent number. You are appearing for the petitioner?
Yes.
Who's the petitioner?
They are
The trust.
no, Your Honor. They are private individuals who are working for the benefit of the locality.
Mr. Your name?
M. Bedia.
M.
Bedia.
Beria. Counsel appears for respondent number 1, 2. 1 and 2. Stop. Let the respondents complete their instructions and file necessary objections, if any. Since the, not respondents, opposite parties. Since the opposite parties are duly represented, notices are waived. Extra copies be furnished within a period of 2 weeks from today.
No, no.
Matter be listed
The fixed date, my lord.
on 20?
20th.
20.
My lord.
January.
My lord, can we on 21st Tuesday hearing date?
So, Your Honor,
All right, 21st.
January. Your Honor, direction may be issued to the state to file the affidavit in the writ petition also.
It is up to them if they want to file.
Because it is very necessary, Your Honor.
If it is not there, we'll pass orders. Why should we force them to file an affidavit if they don't want to file?
And the Your Honor, interim order was there. It will be extended.
That is why he's filed an application for vacating. Interim order is till today.
It is still returnable date.
Okay. Interim order passed earlier will continue till the next date. Yes. Yes.
Below in item number 7.
24.
No, 24. It is item number 27. Our 7 is our item.
What were your objections? Notice.
Notice, my lord, I have got one judgment, my lord, which is against me, although I'm not trying. This issue has come up earlier, my lord, 2018, 5,
Yes, yes.
GLR 226. Then my
Yes.
lord was referring.
This answers the question.
I searched it yesterday, my lord.
This answers the question.
This answers the question.
Okay, Hart. Mr. A. Thakur. Learned Senior Counsel, assisted by MS J.R. Thakur. And also Mr. H. Gupta appearing for the respondents. This application is filed under Section 11 or 6 of the Arbitration and Conciliation Act, 1996, whereby
Number 7.
the demand for appointment of an arbitrator by the petitioner in respect of the disputes arising between the parties, in respect of an agreement, in respect of the contract awarded to the petitioner, was not responded to by the respondents. Stop. Being aggrieved, the present writ petition has been filed. The petitioners was awarded letter of was awarded the contract work. This is at page 13 of the writ of the petition. Page 13.
Yes, ma'am.
Was awarded the contract on 19/1/2017 for the so-and-so work, page number 13 of the petition, subject to legal transportation of it. Stop. Pursuant thereto, an agreement was executed by and between the petitioner on 17/5/2017. Stop. In terms of the said agreement, the petitioner, the work was completed or not? Work was completed. Completed, however.
Because we have been terminated in between. What we have carrying on, then they terminate our.
Although the petitioner carried on the work, the same got terminated by the respondents. Stop. Being agreed, they represented before the respondents for resolving the disputes, and upon failure to do so, the matter be referred to arbitration. Stop. Where is the clause for arbitration?
In contract 63 and 62.
Page 56. Learned counsel for the petitioner refers to clause 64 of the contract agreement to show that there is a provision for arbitration, which was agreed by and between the petitioner and the respondent authorities. Stop. In terms of the said communication, the petitioner filed an application before the authorities on 21/4/2018, requesting the petitioner, general manager, contracts Northeast Frontier Railway, Maligaon, to resolve disputes and highlighting the disputes and requesting the railway authorities to resolve the disputes, and don't say highlighting, you say filed an application raising the disputes, requesting the respondents to sort out the disputes, to resolve the disputes, and upon failure, to appoint an arbitrator in terms of clause 64 of chapter Roman 10 of the contract agreement. Stop. Pursuant thereto, the railway authorities did not respond to the said communication. Stop. Since no response was received, a further notice was issued by the counsels, by the advocates and consultants appearing on behalf of the writ petitioner by communication dated
23/10/20. 23/10/2020.
From where do you
Annexure 8, page 110.
110. No, but where is the date?
It is 115.
In the last page.
23/10/2020. Stop. In spite of that, no response having been received by the respondents, the petitioner has filed his application under section 11(6). Stop. Of the Arbitration and Conciliation Act. Para. The respondents have filed their objections. Stop. Initially, the respondents raised two objections. Not initially, said respondents have raised two objections. First, that there is a panel of arbitrators from which the first that in terms of the agreement, the matter was required to be referred to a dispute resolution committee.
No, my lord, it is a member of, my lord, 3-member tribunal, my lord, at page 57. Clause 64 3A2.
He was required to be, no, this is the arbitral tribunal.
Yes.
Prior to demand for arbitration, it is referred to somewhere.
No, there is no, that provision is not here.
Or is not there.
It's not.
Submits that in terms of the agreement, the arbitration is to be conducted by a member of, by panel of 3 gazetted railway officers, not below the rank of JA grade, or 2 railway gazetted officers, not below the rank of JA grade, and a retired railway officer, retired, not below the rank of SAG officer, as arbitrators. Stop. The railways objected that the panel of names are required to be chosen by the respondents, and only thereafter the respondents can be, the proceeding could have been resorted to. Stop. The further objection is that, as mandated under Section 21 of the Arbitration and Conciliation Act, no notice was served on the respondents by the petitioner. Stop. It is the advocate and the consultant of the petitioner who had issued the notice under Section 21, and which the same could not have been resorted to. Stop. The respondents submit that under Section 21, it is the contractor who is required to issue a notice, and that not having been issued, the respondents did not consider it appropriate to reply. Stop. Para. Learned counsel for the petitioner has referred to several judgments, particularly the judgment rendered by the larger bench of the apex court in what is that? Central Railway Organization reported in so, whereby the majority view of the judgment is that the panel maintained by the railways cannot be imposed on the petitioner, which would prima facie be violative of Section 12(5) of the Arbitration and Conciliation Act. Stop. He further disputed the contentions of the respondents by submitting that the notice was duly issued by the respondents on as far back as 21/4/2018, and whereby the dispute was clearly referred to, and a specific prayer for resolution of the disputes, and upon failure of which, reference to arbitration in terms of clause 64 was required to be made. Stop. That communication having not received any response, the lawyers and the advocates and the consultants issued the subsequent notice. Stop. He further submits that the lawyer having represented the advocate representing the petitioner is to be considered to be an agent of the petitioner, and therefore any act done by the advocate is deemed to be an act done by the petitioner itself. Stop. Where the learned counsel for the respondent, on the other hand, pressed into service the judgment of, what is that, Banarasi?
Yes, my lord, to the Banarasi Krishna Committee and others,
Banarasi Krishna
Krishna-
Committee and others reported in
2012 9 SCC, my lord,
2012 9 HCC
496.
496, as well as the other judgment
2005, my lord, 4 SCC 239.
2005 at 4 HCC 239.
Yes.
Stop. The learned counsel for the petitioner pressing the judgments into service, learned counsel for the respondents pressing the judgments into service submits that this judgment has interpreted the term within bracket parties. Stop. He submits that in the matter dealt with by the apex court, in response to the supply of the award required to be done under section 31 of the Act of 1996, the apex court interpreted that the same has to be done as per the mandate of the Act, namely on the party. Stop. And the party is defined under section 2H of the Act of 1996. Stop. He therefore submits that the same interpretation can be imported into the for the present proceedings. Stop. The demand for arbitration is required to be made by the party under section 21, and the communication dated so and so cannot be communication dated
2310.
21/4/2018 cannot be strictly construed to be a demand for arbitration, as the tenor of the said application is only for resolving of the disputes, and arbitration is referred to only in the penultimate part of the said communication. The communication issued by the advocates dated
23/10/2020
in the context of section 21 cannot be treated to be a notice under section 21 in view of the judgments pressed. Para. Para. Learned counsel for the parties have been heard. Readings available on record have been carefully perused. The judgment cited at the bar has also been carefully perused. The apex court in the judgment dated has interpreted the terms in respect of section 31, where the mandate of the Act is very clear. So, section 31 reads as after. Expect section 31. So, it is also necessary to refer to section 2H as well as section 21 of the Act. The same are expected as after. Having considered the submissions made and judgments rendered, it is seen that the judgments of the apex court define, interpret the meaning of section 31, where there is a specific requirement to serve a copy of the awards on the party. Whereas under section 21, there is no specific requirement that the notice has to be served by a party. Rather, the emphasis is on a notice to be received by the respondent, namely the employer. So, this question came up before this court on an earlier occasion, and a coordinate bench by order dated 7/9/2017, rendered in SLT Infructuous Private Limited, reported in so and so, has answered this question elaborately and has held that any action undertaken by a council at the instructions of the party concerned will have to be accepted as an act undertaken by the party itself. So, in the facts of the present case, the question whether a notice is to be, whether the notice in the present proceeding was issued by the party or by his advocate. The question whether a notice issued by an advocate can be construed to be a notice issued by the party himself, perhaps need not be gone into in the facts of this matter, in view of the fact that there is a communication dated so and so, that 2018, huh?
21/4/18.
Huh?
21/4/18.
21/4/18, which was issued by the contractor, namely the petitioner, to the NF Railway authorities, where there is a demand for referring the matter to arbitration. So, under such circumstances, this court is of the view that the respondent, having failed to appoint an arbitrator, is for the court to invoke its jurisdiction under Section 11(6) of the Arbitration and Conciliation Act and appoint an arbitrator. So, the court therefore proceeds to appoint Justice Amitabh Roy as a former judge of the Supreme Court of India as an arbitrator in the present proceeding, subject to the proposed learned arbitrator giving a written declaration dated under Section 12(5) of the Arbitration and Conciliation Act. The matter, the parties will approach the learned arbitrator by by 12th of January, and thereafter the arbitrator having and thereafter any declaration that may be issued by the proposed learned arbitrator be placed before the court for due confirmation. Ordered accordingly, matter be listed on 12th is a Sunday.
Yes.
We'll say 11th of January.
No, maybe 12, 11, 12 holiday. All from 11th is Saturday.
Right.
So either 10th or 20th, whichever convenient to your lordship.
No. You have to approach the arbitrator first.
Oh, we can approach.
So we'll keep it on 11.
Milo.
11th of January, and thereafter the arbitrator will file. If the declaration will be placed before the court, matter to be listed on 24th of January. Ordered according. We can't.
In this case, Lordship, Mr. Mahanta is appearing, Malak, K. Mahanta, senior advocate. Can it be at 2 minutes? Lordship. Malak, already there is resolved, Malak, since parking, Malak. The parking already we have. No, Malak, since additional affidavit has been filed, Malak, and by virtue of this additional affidavit, Malak, we have stated this 533 square feet that has to be provided in the constructed building itself, my lord. And now, by virtue of this additional affidavit, my lord, we have brought some of the application of the my lord, here my construction has been stopped because lordship kindly have a look at
Your construction has been stopped.
stopped by the lordship have a look the notice, my lord.
No, we want to know what is your prayer for today.
My lord, prayer, my lord, here already as per the notice they asked the petitioner to provide the parking facility, 533 square feet in the existing building.
What prejudice is caused to you if we take it up after reopening?
My lord, prejudice will not occur, but
then we'll take it after reopening.
Yes, but since
because this will have to be heard, it's a question of NOC being cancelled.
No. NOC is.
He admitted the petition admitted he does not have the requisite parking area, my lord. Now he came up with a new facts, my lord, that there are some tenant in the ground floor. We should be directed to vacate their tenant, my lord. Is it possible, my lord?
No. That part tenant is.
That is
part
one.
is
You are representing whom?
Tinsukia Municipal Board, my lord.
So you have given an NOC.
Yes,
sanction.
After physical verification.
He has given an affidavit that he will provide 533 square feet for parking space, my lord. Now he turned around that I don't have that parking area, my lord. Now there are some.
So have you cancelled the NOC?
No, but still not, my lord.
Oh, then we'll take it up.
Yes, my lord.
After the vacation.
Yes, my lord. Yes.
Immediately.
Immediately, yes.
My lord, I've also filed the additional affidavit, my lord.
8th of January.
Your Lordship, in this matter, I am for respondent number 3 and 4. In this matter, senior counsel Mr. B. Datta is appearing.
Mr.
B. Datta, Bhaskar Datta, Your Lordship, senior advocate.
They are
He
the
hails from
private
Tinsukia, Your Lordship. They file an affidavit, will file a reply to that.
File it.
Can it be on 20th of January, Your Lordship? Because
Nothing.
he'll be here personally, he'll be
My
here, Your
lord,
Lordship.
they do not have any locus standi in the case, man.
I'm the neighbor, Your
Only
Lordship.
it is
You let us have it on 8th. You file your response. We'll see what happens on that day. 8th of January?
lordship.
In the meantime, I will also take instruction.
Take your
My
instruction.
lord,
Matter be listed on 8th of January. The
For further
respondents may
hearing.
the respondents may file their necessary affidavits upon completion of the instructions.
my lord, it may be observed as further hearing, my lord.
No, not further.
Just one indulgence. Yesterday I made a mention that for together, but mistakenly it was written 18 minutes. Kindly allow me mention matter for tomorrow.
For tomorrow, all right.
Yes.
Tomorrow.
I'm sorry.
All right. We'll hear it. Don't worry.